the tree cutter guy actually lied about it and said that our guy pulled out a gun and put it to his head.
That criminal conviction may have been a mistake you made 20 years ago, but not revealing it to us today was a mistake you made today.
Didn't even know what kind of dangerous weapon it was this guy was charged with.
It's pretty clear you have to disclose absolutely everything, be brutally, overly honest.
All right, here we go. Welcome to the very first episode of Boston Barristers. I'm Matthew Peterson, and I'm here with my colleague, the one and only Bill Manchinton. See, we're both criminal defense attorneys right here in Massachusetts, and this is where we break down the legal stuff without putting you to sleep.
Kicking things off strong, and yeah, we promise no boring lectures here. This podcast is for real people who want real answers about the law.
So before we dive into the real talk here, Bill, quick question. How's the Boston spring treating you so far? You getting any sunshine yet, or are we still waiting for the warmth to kick in?
Definitely pretty chill so far. Today's about 80 degrees, so definitely enjoying it. So I think we're headed in the right direction. Spring's definitely right around the corner. How about you, Matthew?
Yeah, the problem is always that it's beautiful weather when we're in court all week, and then as soon as the weekend comes around, it's pouring down rain. But hopefully we'll get some more warm weather soon.
I'm hoping. It's looking good. I'm hopeful.
So enough about the weather. Let's get into it. Bill, how many people have asked you in the past month about getting their gun license in Massachusetts?
Wow. Too many to count. People hear license to carry and immediately think it's easy to get, but Massachusetts doesn't really play around like that.
Yeah, exactly. So this is our first topic today. We're diving into how to get an LTC in Massachusetts, what it allows, what can get you denied, and everything in between. So let's get it kicked off. So Bill, what exactly is an LTC in Massachusetts?
So simply it's certification that allows you to carry a firearm in Massachusetts.
Yeah, so there are a bunch of different types. There's the LTC. They used to have like restrictions on them. They can't have restrictions anymore. There's also an FID, which allows you to carry certain rifles, things like that is more restricted. But an LTC is unrestricted. You have the right to carry a gun on you in the state of Massachusetts. So what would you say the purpose of an LTC is?
Self-defense. I'd say most people coming to us looking to apply for an LTC are expressing concerns about self-defense. They want to protect themselves, their families, and their property. We have the Second Amendment for that reason. And here in Massachusetts, you do have to apply for a license. So most of the licenses seem to be for that reason.
Yeah, that's what I'm seeing too. A lot of people just, it's a scary world out there a lot of times, and people want to protect themselves, they want to protect their families, and LTC is a way to do it. And you're right about the Second Amendment. You would think that the Second Amendment covers this, but unfortunately you still have to ask the government's permission to exercise your Second Amendment rights.
Yeah, it's an interesting situation here in Massachusetts, especially considering, as we'll probably cover later, who gets to decide whether or not you get your license.
When you talk to people, what's the first step someone needs to take to apply for an LTC in Mass?
You have to get your LTC application form, and you can get that right off the official Massachusetts.gov website.
All right, so you get the form, and it's, 3 or 4 pages, I think, and then you fill it out. What do you do with it next?
You have to bring it to, most of the time, your town police chief.
Except if you're looking for an out-of-state LTC or certain things like that, go to the state police. But yeah, usually if you're a Massachusetts resident, you go into your police chief with that filled out application, $100, your certification of your firearm safety course, and you turn that into them. They'll do your fingerprints. How does the process work after you turn in your LTC application?
So the top official, whether that's the police chief in your town or a Massachusetts state colonel of the MSP, is going to review your application and get back to you and let you know whether or not you've been approved.
What's typically the timeline for that?
That I don't know. What is it, 60 days, Matthew?
Yeah, so the statute itself says 60 days, so they have to act on it, but I found that that's routinely ignored, and they don't do it within the 60 days. I mean, it's an important thing, right? I mean, if you're applying, you're asking the government, hey, I'd like to exercise my constitutional rights here. They should act on it quickly, but unfortunately, they don't really seem to.
Hmm.
So yeah, usually they're supposed to act on it within 60 days, but a lot of times they don't. So basically, to break it down, you fill out the application, you get your $100, you take your firearm safety course, there are a bunch of them all around Massachusetts. That'll teach you how to use a firearm, and it's really important how to avoid getting in trouble with your gun. And then you give all that to the police department. They're supposed to make a decision within 60 days.
What are the main requirements someone must meet once they've submitted that application to be approved?
So basically, there's an intensive background check. There's certain prohibitors based on federal law and state law. Like if you're dishonorably discharged from the military, if you were ever committed for your mental health or substance abuse. Committed means you had to go in front of a judge and the judge had to involuntarily commit you. Or the most common one we get is criminal convictions. So if you have a felony conviction or a conviction for a misdemeanor of domestic violence, then those are disqualifiers federally. That means that you can't get an LTC even if the police chief wants to give it to you. So that's the most common thing is you got to look at the statutory prohibitors. Are there any prohibitors that make it so that you cannot get an LTC? The next requirement is a little bit more squishy. It's called suitability. What's supposed to be an objective decision, but is really a subjective decision about whether you're a suitable person for a gun, whether they think that you pose a safety risk. Did I miss anything there?
No, I think that accords with everything that I know. So what are some of the most common reasons you see people get denied? Because you said that it's up to the chief and there can be a suitability or statutory denials. What's the most common?
Yeah, so suitability comes up a lot for us. I mean, because if you have a statutory disqualifier, then really you have to remove that statutory disqualifier. But a lot of the people that come to us come with suitability. Isn't that what you found?
Yeah, absolutely. Because a lot of the times people, they might not have a conviction on their record, but they do have dismissals, and a lot of the times the police reports are accessed in these cases. And so the police chief will read the police report and he will find that you are unsuitable, even though you were never actually convicted of that crime, which I find troubling.
Troubling is to put it mildly. And yeah, I mean, the worst part is I've had cases where they didn't even read the police report. They just read a person's record and said, oh yeah, you have an assault and battery with a dangerous weapon. And
that's outrageous.
And I said, well, what dangerous weapon was it? And the police chief didn't even know. He didn't even know what kind of dangerous weapon it was this guy was charged with. And a dangerous weapon can be a shod foot, which means the shoe that's on your foot can be a dangerous weapon in Massachusetts.
Yeah. So when you have the guy who's supposed to judge your application not even reading your application, that's kind of a problem.
Yeah. And in that case, by the way, that dangerous weapon.
What was it?
A tape gun.
Wait, a tape gun?
Assault and battery dangerous weapon tape gun.
That's ridiculous.
I've seen assault and battery dangerous weapon tape gun, sack of potatoes. This might be my favorite one.
Really? Wow. Well, you know what? They got some heft behind it, so I'll give them that one.
Right. So they actually look at not only your state record, but also they do federal record. So even if you get approved at the state level and the local level, so the police chief usually will run your background through Massachusetts and will see, oh, well, this guy was arrested in Everett for blah, blah, blah. They'll try to get the police report and read it if they're doing their job. Then after that, they send it to the state, the CJIS, which is in Chelsea, the Criminal Justice Information System. They'll look at your state record to make sure there are no prohibitors. And then it goes to the FBI. And the FBI actually does a nationwide background check. For you. And unfortunately, these nationwide background checks are a huge mess because a lot of times the courts never update the FBI on what actually happened to the case. So that's where a lot of people get bogged down, is that FBI background check there.
So what do they do when they are denied? What are their options?
So if you are denied an LTC, you have the right to appeal. So you'll get a letter in the mail, and the letter will say that you have a right within a certain period of time, it's 90 days, to file an appeal with the district court. basically what you do is there's a petition that you file that says when you were denied, why you were denied. You bring a copy of the letter. You pay the $195 filing fee, and the district court that's over the police department that denied you, and they'll set it up for a hearing.
Okay.
But
So what happens at that hearing?
So at the hearing itself, you're actually able to present both evidence of your suitability. So you're able to actually call character witnesses, have people testify on your behalf. You're able to testify on your own behalf and say, here's why I'm a good person, and here's why the police department made a mistake by denying me. But the big thing is that this suitability is so wide ranging, so that they'll look at not only criminal charges, but restraining orders. So if you had a restraining order against you from 10 years ago, and let's say that restraining order was never even brought to court, right? So it was,
just a temporary one, right? Like the 7-day ones you're talking about, where they don't even have a full hearing yet.
Yeah, you might not even have the right to go in front of the judge for that, because there's an ex parte order that's entered for 10 days. And at the end of that 10-day period, let's say that the person decided they didn't want to go forward. That shows up on your record, and that can be a reason to deny you. Right. Even things that aren't charges, or you're never charged with, can also be considered. So even if the police department never decided to charge you, they can look at police reports, things like that, even non-criminal acts. Like if, the police come to your house and they see you drunk, or they see whatever, they produce a report from that. The police department can see it, and they say, well, we don't think you're suitable because we went to your house and you were sort of belligerent. Even though there wasn't criminal, you could still be charged with that. And the important thing is that in Massachusetts, it's any crime that carries more than 2 years.
Is a prohibitor. Wow. Okay.
Right. So like even an OUI conviction is a prohibitor.
Okay. So assault and battery.
Yeah. Assault and battery. Pretty much the only ones that aren't are like very minor things like trespass, shoplifting, things like that. But like I said, those still go into the suitability determination.
Right. So even if you're not automatically statutorily prohibited by a conviction with one of those charges, they can look at the fact pattern of those charges and find you unsuitable anyway. Exactly.
So that's what happens to a lot of our clients. Is, I don't know how much you've seen this too, but there's something that you were charged with that was dismissed, or something that you were never charged with, or something that you were charged with and you were found not guilty of.
Right.
The police department can say, yeah, but we still think this is a credible threat to public safety, so we're going to deny you. Even though you never had the chance to fight it in court, or you fought in court and you won, even worse.
Yeah, that's scary. That's scary that you could have a not guilty and that's used against you. I mean, that's wild.
Today's episode is brought to you by the Law Office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the Law Office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation, or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show.
What's the craziest reason you've ever seen for a denial?
So we represented a guy, Army veteran, worked for the fire department, and he actually was carrying his gun when he saw his son being threatened with a chainsaw in his yard. A guy was cutting down a tree. This guy was threatening his son, cornered him, and had a running chainsaw in his hand.
That is psycho.
Yeah, and the guy just goes downstairs, confronts the guy with the chainsaw, has his legal gun in his pocket, never pulled it out, never threatened the guy with it, never even mentioned it. He didn't say, yeah, I'm going to pull this gun out and shoot you or anything like that. He just had a gun in his pocket. And the police chief suspended his LTC and worse, stood by it. We had to have a hearing about it. And he said, the police chief stood up there with a straight face and said, oh, what he should have done is not brought a gun into a dangerous situation.
That's wow. How does self-defense work if you're never allowed to bring a gun into dangerous situations?
Exactly. So, I mean, if your son is being threatened with a chainsaw, a running chainsaw, and you're not allowed to bring a gun into that situation, then how do you have a right to self-defense?
It completely guts the Second Amendment, to be honest, if that's going to be the standard of conduct. But wow. Okay. So what ended up happening with that client? Did you guys appeal?
So yeah, we appealed. We had a hearing in front of the judge. We showed the judge the video, and the judge luckily restored the guy's LTC.
Oh wow, it was a video.
Yeah, so the son actually recorded this. The story actually gets even crazier than that. I mean, I think we have another video about it too, but it gets crazier than that because the tree cutter guy actually lied about it and said that our guy pulled out a gun and put it to his head.
Wow.
And there was a video, the son actually took a video the entire time and showed that never happened. So even though the police charged the tree cutter with assault with a dangerous weapon, chainsaw, against the son, charged him with filing a false police report, didn't charge our guy with anything, they still stood by his LTC suspension.
Wow.
Yeah, I mean, it's absolutely ridiculous. Basically what happens is that once you file this appeal in the district court, they usually set a hearing a couple months down the road. What we usually do is we'll request discovery from the police department. We want any written regulations they have, which, spoiler alert, there are no written regulations dealing with these in any police department.
Right.
They basically just say, they don't say, well, if it's a 10-year-old domestic violence dismissal, we don't consider that. They basically look at each case individually and make a decision based on that.
Just however they're feeling that day.
Exactly. They lick their finger, they put it in the air, they figure out suitability or not suitable. And but we ask for those things to just show the judge, hey, they don't have any regulations about this. They don't have anything written about their rules for this. It's just whatever they feel on that day. And then we'll also request any documents they have relative to suitability. We want to make sure there are no surprises when it comes to the hearing, that they don't try to change the battlefield on us and say, well, I know we said in the letter that you're unsuitable because of this, but actually we also think you're unsuitable because of that. So we try to eliminate surprises and also anything specifically that we have.
So what you're saying is you're trying to lock them in so that when you show up to the hearing, you know what's going to be said and you can prepare for it.
Exactly. So we know essentially what their case is going to be so that when we are presenting our case, we're not caught by surprise with anything.
Okay, so for everybody out there who is thinking about applying for their LTC, what do you have to say to them? Any advice?
So I would say that the first thing is talk to somebody, talk to an attorney. I mean, if you have any questions, if your case is in any way complicated, you want to talk to somebody and figure out what the best way to do it is. Because the one thing that we have that we represent a lot of people on, and the one mistake they make in their application is they're not brutally honest. So let's say you had a case 25 years ago that was dismissed and you forget all about it. There's a box on the form that says, have you ever appeared in court as a defendant? And you forget about it and you say no. Then that can be a reason in and of itself to find you unsuitable. Right. So if you make a mistake on your application.
So because what they're essentially saying is that criminal conviction may have been a mistake you made 20 years ago, but not revealing it to us today was a mistake you made today. And that's
Exactly.
another grounds for denying it because of that dishonesty. So
Exactly.
you're able to help people dig up their court records, or how do you help with that?
So yeah, what I usually tell people is when they're thinking about this to go ahead and pull their Corey. You can pull your Corey online.
What's that? What's Corey?
A criminal offender record information.
Okay.
So you can actually go online and say, Massachusetts Corey, put it into Google. And I say review that and make sure that it's correct because that's what the police are going to review. And a lot of times in that question, I just say, see attached Corey. And attach the actual Corey to your application so that you're not mischaracterizing something. Because a lot of people, non-lawyers, they're like, oh, yeah, that case was dismissed. Well, actually, you paid a fine for it and pled guilty. Or, something like that. Like, you don't want to mischaracterize what is in your record on your application.
Right. That's why it's so important to make sure that every detail is correct in your application, because if you make a mistake, sometimes they'll interpret that as an intentional act to try to skirt the system or to hide something. You don't want to be in that position because then they don't give you the benefit of the doubt anymore.
Exactly. And that's the problem is that, no one goes into the police station thinking, hey, I'm going to hide my criminal record from the police.
Right.
I don't think there's anyone out there
Right.
who thinks that the police can't find these things. It's just they forget, right? I mean, you'd forgot that you went to court 25 years ago or whatever for something minor.
Or somebody took out one of those restraining orders and you never even thought it went into effect. You didn't even know it was official or not.
Exactly. So it's just important. So the whole idea, there's a First Circuit case on this where they actually say that the court can consider the person's dishonesty in their application and finding them not suitable. I think the whole thing is hogwash because it's like, why I'm not being dishonest with you. I'm just trying to disclose everything, but I forgot. And they don't give you the benefit of the doubt.
Right. And then some people, they try to, guard their constitutional rights and they try to only disclose that which they think they need to disclose. And they don't want to disclose everything because they don't think they have to. But that's why it's so important to reach out to a firm like ours, because we can help navigate those choices. What can you disclose? What should you disclose? And where that line is. But most of the time, it's pretty clear you have to disclose absolutely everything, be brutally, overly honest. But if you're looking for a consult, you're available, right, Matthew?
Yeah, definitely. So we do application reviews. So if you want to actually send us your application and we'll take a look at it, review your record, talk to you about what you should put on the application ahead of time to make sure that you're not falling into these traps, because there's so many trip minds to the unwary, right? Like imagine if and this is a constitutional right we're talking about. Like imagine if when you went to register to vote, if you put the wrong apartment number down or you forgot to put an apartment number down, they were just like, nope, you lose your right to vote forever. A paperwork mistake can cost you that. And unfortunately, judges around the state have upheld that. Have said, you know what? Yeah, you made a paperwork mistake, but it seems kind of dishonest to us. So we're going to deny you for that reason.
Right. And then you may, based off that first application attempt, it sort of sours all further ones. And you don't want to be in that position.
Exactly. So if you get denied the first time and then you apply again and fill out the application correctly, they could say, well, you were dishonest the first time, even though that's absolutely ridiculous. So yeah, I mean, if people have any questions about what do I put, because the other problem is like, there's some states that have expungement laws where there's the expungement law actually says when they get an expungement letter, I've seen some of these, say you are allowed to say this never happened. Legally, factually, this incident never happened. And people are confused. It's like, well, should I put it on the application? Because it says, have I ever appeared? But then I have this letter that says it never happened.
Right.
So there are a lot of situations like that where I say, listen, just be overly honest with them so that they can't say that you weren't.
Right. Right.
So anything that comes up, I mean, you don't have to disclose every single speeding ticket you've ever had.
Right.
But I mean, I don't think even that would be a bad idea.
Yeah. Yeah. Why not? Don't give them ammunition to use against you. Pretty much includes that.
Also, if you lose in district court, so say the district court denies you, then you also have the right to appeal up to the Superior Court. But the problem is the Superior Court review is confined to just what happened in the district court. So we have a lot of people who think, hey, I'm gonna do this on my own. I'm gonna do this hearing on my own, and tell the judge what happened, and I'll be fine. But unfortunately, what happens is that then you didn't make the record well enough for the Superior Court to review it. So if you come to us after that initial hearing and say, listen, I lost in district court, what can you do for me? We can certainly do what we can, but it just becomes that much tougher.
Right.
Because you want to have a robust record in the district court of who you are and why that police department was wrong to deny you. So, all right, that wraps up our very first episode of Boston Barristers. We hope you found our breakdown of license to carry process in Massachusetts helpful. So whether you're applying for an LTC or have other legal questions, we've got your back.
Absolutely. If you guys got questions about getting your gun license or anything else legal, don't hesitate to reach out to us. We are always here to help guide you.
And make sure you subscribe to our YouTube channel for episodes like this one. Share this with your friends, and don't forget to hit the notification bell so you never miss an episode. We've got tons of legal insights coming your way. And in our next episode, I'll be joined by Chris O'Brien, and we'll be diving deep into white-collar crime cases. So if you're curious about complex financial crimes or what to expect in this kind of cases, you definitely don't want to miss it.
Looking forward to it.
So thanks for tuning in, folks. Stay informed, stay safe, and we'll catch you next time on Boston Barristers.